Alison, thank you very much for a second very interesting presentation. The floor is open. Depending.
I don't want to start, but I do wait. But thank you, Alison, and thank you for wonderful presentations, very graphically. Alison, when I used to have to teach separation of powers, I always used to say, give an example. Whenever I draw a check, my bank says there is no balance. Theory of checks and balances is quite complicated in real life. But seriously, I would suggest two things to you if I would. So one is the notion of dialogue is an intensely theological notion. And I worked on Martin Buber, IND and other works. And when we move into secular sphere of democracy, there are both problems and opportunities. And I won't go further than that, given the paucity of time. But certainly, so the dialogical enforcement, and for enforcement, we have to rethink when we think of directive principles as entailing dialogical enforcement, which is not out. Court shall not enforce a directive principle, which doesn't mean that it should not dialogue with the legislature or parliament in this case. So there are 5 or 6 types roughly of enforcement. One, coercive enforcement. Coercive. Second, persuasive dialogical. Thirdly, policy enforcement. Fourthly, symbolic enforcement. And finally, instrumental enforcement. You can play around with this. So enforcement, is a very good question. What does it mean in the Constitution? And I also wanted to say, lastly, that Roscoe Pound wrote before you were born, and I was born, I was 28, Tulane Law Review, a very germinal article. I was a feminist, practicing feminist, a germinal article, which was based on the forms of law, in which it distinguished between ideals, goals, principles, maxims, precepts, and rules. And there was an upward arrow and downward arrow. The movement was in there. So the formalists have been right and wrong. As you know, John Austin made a habit of habit. Right? Hart then moved to the idea of rules, Herbert Hart. And then Dworkin moved from rules to principles. So your question, what is the distinction between rules and principles? What happened after Dworkin, I don't know. Don't study Oxford that closely. But surely there's a movement with Coleman and others. I don't know what is the rubric, Penish, what they have done. But my reading stops at Dworkin. Therefore, it's all a simplest web actually. It's not one thing or the other. But I will stop.
Thank you very much. Would you like to respond?
Yeah, sure.
Just keep it brief because we only got a limited amount of time.
What is dialogue and what does its importance in constitutional? The difficulty with the work I've been looking at is I didn't choose the term dialogue and it's not what I would have chosen. I wanted to investigate it because the word dialogue had been used quite frequently with regard to these models of human rights protections which I was looking at, where you don't have a strong constitutional protection of rights and there's meant to be a role for the legislature. And it came from the some early Canadian literature. And I think there are huge problems with the word dialogue because it assumes all sorts of things that don't necessarily translate into the structure of what's going on in the Constitution. So it often, as you say, it assumes some kind of nice, fair, framed, rational discussion between equal parties. And you're absolutely right, that doesn't necessarily translate to what happens in interinstitutional interactions, which is why I've been looking at sometimes the dialogue is really about protecting your powers, and sometimes the dialogue is about trying to work together, and sometimes trying to protect your powers somehow inadvertently leads to, it's almost like collaboration by accident. You're kind of so concerned about the reaction from your institution, you'll err on the side of caution because you're anticipating a reaction, and that will push you in a different direction. So you're right, the word dialogue itself is very difficult. I think it's also difficult in the constitutional context because a lot of the work is built on generalizations about characterizations of the different different institutions of the Constitution. So we have kind of stereotypical characterizations of how judges reason, how legislatures reason, and the interactions between the legislature and the executive that don't necessarily match reality. So you're right, there are lots of problems of transferring it down. And I think maybe we've chosen the word dialogue, or maybe it was used to bring these extra kind of philosophical, religious connotations you mentioned, to give it a kind of extra value that it doesn't necessarily have.
I agree that the question of enforcement is important, but the Indian literature so far has usually worked on three words. There's an extensive literature which talks about the bar in Article 37 as being a bar about justiciability. And the word justiciable is not in the Constitution. Even so, there's a bulk of literature talking about why Article 37 makes Part 4 non-justiciable. So that's a far more extensive restriction. The other part of the literature focuses on the word cognizable. And go all the way back, P.K. Tripathi in the 1960s, though his position was that the court should use directive principles, organized the discussion entirely to be a discussion about cognizability. And Benegal Rao very specifically in an earlier draft moved from cognizability to enforceability. And that's what distinguishes the Indian and the Irish constitutions. So with respect to directive principles, where the Irish constitution places a bar on cognizability, on Catholic social doctrine. And there's published work, Hannah Lerner and other work, which doesn't make this distinction. At least as maybe political scientists don't see the point, but as lawyers, that's important. But does enforceability in the bar on enforceability in Article 37, does it automatically push us into a weak form judicial review? And I know that Professor Singh has written about this in a review of Tashnath's weak and strong judicial review. Do we automatically move into this dialogical mode or some sort of soft judicial review? And my instinct on that is no. I think what's important in the Indian Constitution is the priority of enforcement. Is that the court cannot have the first stab at it. It cannot issue a mandamus on any principle in Part 4 of the Constitution. But once the legislature, the executive acts, it can issue a mandamus. But the immediate point of authority there is the state action. It's not the principle itself. So I think that it's a little more complex. So I wouldn't imagine that Part 4 implementation will mean only weak judicial review. But I haven't, as I was saying to Alison, that the more I think about the problem, the more the chapters keep changing. So but my instinct is not weak judicial review. I'll just say one thing about the form of law. I think the form of law argument is important. Does it make a difference that it's a right and a principle, a right in Part 3 and a principle? In the chapter that I've written, I haven't rested too much on just that distinction, but maybe I should say more separately.
Thank you both for a really interesting session. I have two interrelated questions for Alison. The first is I share your concerns about the word dialogue, and I think it's becoming the metaphor that eats the reality, that we try and tailor the reality to fit the word rather than vice versa. So my first simple question is, have you come up with a better term? Is there something that would be more descriptive? The second question is, once we move past some of the types of dialogue, describing some of the types of dialogue that happen already, which can often be somewhat antagonistic or based in one's own, protection of one's own power, to a more cordial form of dialogue that you describe. You might get the maximum, at least hypothetical benefits. I don't know that we've actually seen this type of dialogue anywhere, so those benefits remain hypothetical. But if they come at, as you call it, reimagining things like the separation of powers, which have some real and tangible benefits, are we sure that those hypothetical benefits of cordial dialogue actually outweigh some of the existing and important benefits of doctrines that would need to be reimagined? Thank you.
I'd love to say I've come up with another term, but instead of trying to come up with another term for it, I just felt I had to live with what was out there. But what I've tried to do is as I said, separate out these two different types of, general types of interaction concerning what I call parity mechanisms, which is building on work I did with Nick Barber on a constitutional self-defense mechanism, and also looking at this element of collaboration. So interinstitutional interaction is about the best I can come up with, because I don't think they're necessarily talking to each other in the way we'd understand talking, but they are interacting with each other. So that's the best alternative I've been able to find. It's also nicely alliterative, so that's always good in my book. With regard to your second point, I think I would be more concerned about whether these benefits that may ensue would outweigh the problems of having to reimagine the separation of powers if I felt that what dialogue is asking these institutions to do is something completely different from their normal role, or if what it was asking them to do was to kind of completely get rid of the separation of powers. I think what I've now decided is now interinstitutional interaction is asking is really builds on a pre-existing separation of powers in some senses. So a lot of the arguments of why the institutions should interact is because we're recognizing these institutions are composed differently, have different functions, and because of their different compositions and different functions, they then have different strengths and weaknesses when it comes to human rights arguments. So sometimes the interactions are built on, they should be built on and reflect pre-existing institutional features, and they also are built on and reflect pre-existing constitutional structures. Different constitutions will give different relative authorities to these different institutions, and the interactions have to be built around those and reflect those, otherwise you're right, they're not going to work and you'll take away more than you achieve. But you also, I think, as you rightly point out, need to balance this against current understandings, not just in the practical sense of you can't force institutions to do something different from what they're used to doing, but also because the separation of powers is there for an important reason, which is why I want the checks and balances built in there. And also to be wary of how far you push dialogue or interactions. Interactions work better in situations where the institutions are able to give reasons for what they're doing, encouraging transparency, so you then get reflection on those reasons as you argue back. So this should hopefully encourage better collaboration. This is being taken in some theories to suggest that you should have things like constitutional road mapping, so that courts should not just decide a case, but then should decide, I know, let's have lots of dicta about, if I were to achieve these objectives, how would I achieve them, how could I do them in a different way? And I think that would be going too far, because that would be cutting across an important aspect of the separation of powers. So you're right, the benefits do need to be balanced against the separation of powers arguments and built on pre-existing separation of powers.
Okay, now we have about 3 more questions and we're running out of time. So, what I'm going to propose is that I take the 3 questions, I'm going to take all of them, can you be brief in your question, and then instead of asking our 2 panelists to reply seriatim to each of the questions, we're going to aggregate all 3 of the questions, and then they can have a response to all 3 of them insofar as they are directed at our 2 panelists respectively, and answer at the end. Okay? So Taran first, then Aaron, then...
Thank you, I'll be very brief. Sudhir, this is something you flagged as a part of the book that you didn't speak to. But there's always been a slight sense of embarrassment about directive principles in some progressive movements because of the place of cow slaughter provision. And also, of course, because of the disagreement on the Uniform Civil Code clause, and I was interested if you could speak to your idea of whether there's a meta principle, what unites these principles, and whether that sense of embarrassment is perhaps misplaced or a way is there to respond to it.
Aaron.
Question, drawing from what I see as a very common link between the two papers. So I think drawing from what Alison's been saying about collaboration, I think there's some scholars have talked about facilitative approaches that judiciaries can take. Let me just speak up, stand up here. So the question is to Sudhir, if you were to take this, so you explained that you are not advocating a weak form judicial review, but some people, taking the right to food case particularly, have said this is an instance where the court is not even laying down rights or talking about what's happening. It's taking some existing governmental policies and insisting on their enforcement, which eventually leads to the implementation and to further legislation on the Food Security Act. Right? So this is some kind of interaction, interinstitutional interaction, but not along the ways that people would find problematic in other contexts. So would that be a case study for the kind of, and I guess it's a way to get you to also say what your position is normatively. And
Last one. Can we get the mic?
Thank you, Alison, Sudhir. So my first question is to Sudhir. Sudhir, do you think that many scholars of the Indian legal system over a broad range of time have commented that courts have, maybe in the 50s, have looked at Article 38 in terms of reallocation of resources. In the 70s and 80s, it's been about expansion of Article 21. So do you think that the directive principles have come to mean the courts responding to the existing social realities in some sense? And that's my first question. And my second question is to Alison. Alison, a good example of interinstitutional dialogue could be thought of as the declarations of incompatibility under the Human Rights Act, which is an interesting example. So do you think that interinstitutional dialogue is possible in a country like India with a strong form judicial review? Thank you.
Thank you very much indeed. So, why don't we just take it? Sudhir, you go first, and respond to the points, and then Alison.
So Tarun's question on cow slaughter, I'll say two things. So we have a provision on banning cow slaughter. It doesn't say ban, but it talks about animal husbandry and prevention of cow slaughter. And it has been a source of embarrassment, as Tarun said, for those who would otherwise argue that the constitutional values are rather impeccable in their integrity and so on. I wouldn't go that far even about a description of any constitution, but let me say two things about the cow slaughter provision. At no point do I argue that directive principles are trumps, because individuated rights protection is the state's job, is the court's job. So that no directive principle has a free run, in no principle. So the tension doesn't go away. The courts have to do the difficult normative task of reconciling rights protections with principles of justice. That doesn't go away. So that's the first thing on cow slaughter specifically. So I have no particular embarrassment about advocating the same position with respect to the cow slaughter provision as to any other provision in Part 4. Second question you asked me was, how would I characterize the entire set? I worked quite hard at that. And if I were to put it in one phrase, I would say Republican non-domination. Anti-hierarchy is what runs through Part 4. And in my reading of Part 4, every single provision can be threaded through. Now this is a reconstructive account. Nobody in the Constituent Assembly used Republican or Republicanism in this way. They only used it as an anti-monarchy principle. But the best reconstructive political justification I can think of is this kind of principle. It also has the domain of the social and the economic rather than the political as its target. And republicanism, political philosophy, has the same kind of ambition. On the right to food, for me, the right to food case is Exhibit A. It's what the court should do. They should go out there and enforce executive policy that advances directive principles, and they should do this with strong review, with mandamus orders, with contempt powers, with the entire armory that the court has at its disposal. So for me, that's the perfect example of what the court should do. I leave the dialogue question to Alison because I'll just respond to Gaurav in a short way. The sharp insight that I've come to through this work has been that the entire story of post-1950s constitutionalism, the historical narratives of Indian constitutionalism are, in my mind, completely misplaced. They are too court-focused, and they give too much weight to the judicial self-perception and the judicial narrative. This whole idea that come the 1970s, the court discovered poverty for the first time in India and then has gone about vanquishing it is an absurd narrative. And when one considers that that is the dominant narrative of the Indian Supreme Court, is the standard chronology. Conservative, governments did nothing, 1950 to 1975, then the court discovered poverty and then went about eradicating it. It's the most absurd narrative, and it's astonishing that that has survived for so long. So I would change that, and that's part of what I'm trying to do with my work. I would change that narrative, and we need to rewrite that part of the history of the court.
Just respond to Gaurav's question. With regard to how can you have interinstitutional interaction in systems with strong form judicial review, it basically looks at how the institutions exercise the powers they've been given within that particular constitution. So if you look from the perspective of the courts have to interpret what rights are. And sometimes they have absolute rights, and sometimes they have rights that can be balanced against other rights and interests. And the courts can define rights very precisely, or they can define rights quite loosely. So there's a range of different possible legislative solutions that would still be compatible with different human rights provisions. And the same when they're balancing rights. They can require very stringent balancing that puts very clear confines of what the legislature can do, or they can be more fluid and say a range of different possibilities would satisfy the balance between these different competing interests. So in this way, they're giving space, in some sense, to the legislature. Now, obviously, the legislature then has to be able to respond in some way by reacting to that space. So the legislature can respond by reenacting legislation, either because they think something was unconstitutional when it shouldn't be, and it will take the guidelines from the court decisions and think of ways of reenacting the legislative policy in a way that takes account of the judicial decisions. So there can still be interinstitutional interaction in that way. If that's going to be done in a collaborative way, then you need to make sure that the courts give very clear reasons and justifications for why they've reached particular conclusions, and maybe allow the courts to have some leeway within that to have dicta without setting out clear, oh, by the way, if you do X, Y, Z, then this will achieve an objective, which would be to go too far and transgress their powers. And it also relies on legislatures, when they're reacting to these particular constitutional decisions, to set out clearly why they're doing so and to refer to those judgments and explain their particular responses. So that's how it could be done, but it does require the actors to act in a particular way in order to achieve it.
Thank you very much, everybody. I think we should express our thanks to our two excellent panel speakers. I think we're going to move straight on to the next session. We have gone over a little bit. On the other hand, we did start slightly late. So, without more ado, thank you very much indeed.